welcome to the debate. Today, we are immersing ourselves in one of the most sobering rulings in U.S. legal history, Buck v. Bell. This was the 1927 Supreme Court decision that upheld the compulsory sterilization of those deemed feeble-minded for the supposed protection and health of the state. It really remains a terrifying inflection point in American jurisprudence.
It absolutely is, and it's a critical study in how legal frameworks can be hijacked by flawed, and I would even say malicious, social engineering.
Precisely. So the core disagreement we're tackling today centers on the legal philosophy that Justice Oliver Wendell Holmes Jr. articulated in his majority opinion. He prioritized what he saw as state necessity and this concept of police power over the individual autonomy of Carrie Buck. We're debating whether that original rationale, which, let's be clear, provided the legal foundation for decades of abuse, was a constitutional necessity given the legal landscape of 1927, or if it was just fundamentally flawed from the very outset.
And I'll be contending that the legal rationale was fatally flawed, that it was built on manipulated evidence and, frankly, judicial overreach. My focus will be on the principles that eventually triumphed over Buck v. Bell, the skepticism in lower courts, the successful legal challenges that followed, and the legislative efforts that recognized sterilization abuse as a profound violation of fundamental rights.
And I'll present the original constitutional rationale behind the decision, arguing that the ruling really must be viewed through the prevailing lens of state police power and judicial deference that, dominated legal thought during the Progressive Era. So the Supreme Court's ruling affirming the Virginia Sterilization Act of 1924, a statute based heavily on the eugenicist Harry Laughlin's model law, it really can't be separated from the prevailing legal philosophy of that era. This was a time when the state was viewed, especially by progressive reformers, as a mechanism to improve the welfare and efficiency of its citizenry. Holmes's majority opinion wasn't just a burst of raw ideology. It was an attempt to ground this surgical intervention within existing constitutional precedent, making a legal analogy that, at the time, seemed quite robust. The key to understanding this position lies in Jacobson v. Trace, Massachusetts from 1905, where the court upheld mandatory smallpox vaccination. Holmes argued that if the state can compel a citizen to submit to mandatory and, yes, potentially invasive action, a vaccination, for immediate public safety, then it must possess a comparable power to prevent those believed to sap the strength of the state from perpetuating what they believed to be hereditary unfitness. It was framed not as a punishment, but as a necessary, if minor, surgical measure, in Carrie Buck's case, a self-injectomy, to protect the community's long-term economic and social stability. It was an argument of proportionality. If the state can demand a minor sacrifice for immediate health, they reasoned it can demand a permanent one for enduring public welfare. And this judicial deference to legislative findings of social necessity culminated in that famous and, deeply regrettable conclusion: 3 generations of imbeciles are enough.
I appreciate that historical framing, I do. But the comparison between mandatory vaccination and compulsory permanent sterilization is, for me, where the constitutional argument instantly collapses. The legal foundation was suspect from the moment the Virginia law was even drafted, and you can see that suspicion reflected in judicial challenges against similar state laws. For instance, Indiana, which was the first state to pass a sterilization law back in 1907, saw that very statute overturned by its state Supreme Court in 1921. So this demonstrates there was already a legal tradition of skepticism about this kind of overreach of police power, even before Buck v. Bell got to the Supreme Court. And this is crucial. The Buck case itself wasn't a legitimate dispute. It was an engineered test case. It was specifically designed to secure legal precedent. It was masterminded by proponents of eugenics, including the colony superintendent, a Dr. Pretty, and the act's drafter, Aubrey Strode. Carrie Buck's court-appointed lawyer Irving Whitehead was a close associate of Strode and a staunch believer in forced sterilization. His defense was notoriously weak. It's often described as a functional collaboration with the prosecution. The core factual finding, that Carrie, her mother Emma, and her daughter Vivian were all feeble-minded, was deeply, deeply flawed. It relied on primitive, culturally biased IQ tests and just social conjecture. Carrie Buck had been an average student for 5 years. Her institutionalization was arguably an attempt by her foster family to hide the fact that she had been impregnated by her foster mother's nephew. And her daughter Vivian was also considered of average intelligence by her school staff shortly before her tragic early death. So the decision fundamentally violated the Due Process Clause of the 14th Amendment by denying a citizen procreative liberty without any adequate factual basis or constitutional justification. The whole premise was built on a legal fiction.
Okay, but we have to maintain the historical perspective. I acknowledge the egregious corruption within the factual record of the test case itself. I do. However, the Supreme Court, in its role as a reviewing body, typically does not substitute its judgment for the factual findings of lower courts or the legislative branch, unless the law is deemed completely arbitrary. The legal question before them was procedural. Did Virginia provide due process for the administrative finding of unfitness, and was the law a legitimate exercise of police power? The majority concluded yes on both counts. Let's return to the Jacobson analogy for a moment, because this really is the hinge upon which the legal philosophy turns. If the state is justified in imposing mandatory and, yes, sometimes invasive action to prevent the rapid spread of a communicable disease, a clear and present danger, why, from the perspective of the 1927 court, would this principle not extend to addressing a long-term, hereditary threat that the prevailing scientific consensus of the time insisted was degrading the social and economic capacity of the state? They viewed it as just another form of mandatory public service or health regulation.
I'm sorry, but I just don't buy that the analogy holds up under any serious constitutional scrutiny. Reproduction is and has always been recognized as a fundamental element of liberty and bodily integrity. It's not like the temporary health mandate seen in Jacobson. The distinction lies in the severity and the permanence of the infringement. Vaccination is a temporary measure. It's designed to protect against an external threat. Sterilization is a profound, permanent alteration of the body that denies the capacity to reproduce, a foundational human right. The court was being asked to sanction state control over an individual's very identity and their future lineage. Justice Pierce Butler, who was the sole dissenter in Buck v. Bell, implicitly recognized this. His refusal to write a dissenting opinion was a kind of silent protest that spoke volumes about his alarm. Furthermore, the very concept of state necessity requires a valid factual predicate. The supposed science that this was all built on, that things like poverty, moral laxity, and feeble-mindedness were strictly hereditary, that was demonstrably false. It was built on class bias, nativism, and racial prejudice. The legal premise of maximizing collective health was conceptually flawed because the factual necessity, the imminent hereditary danger, it simply did not exist.
That is hindsight informing our judgment, however. The judiciary can't easily substitute its own evaluation of social necessity for that of the legislature. In 1927, the legislative findings of fact, supported by testimony from influential figures like Harry Laughlin, suggested that hereditary defectives cost the state vast sums of money and lowered public health. The Supreme Court was relying on the established scientific consensus of the day, even if we now understand that consensus was tragically corrupted by eugenics. The court held that if the legislative classification has any rational basis, they have to defer. Holmes specifically framed it as a necessary sacrifice for the common good.
But when that sacrifice involves the permanent destruction of a person's procreative capacity, the standard for rational basis has to be extraordinarily high. And the failure of the court was its willingness to accept a prepackaged, biased argument, one that ignored the fundamental rights at stake, and to categorize sterilization as just an administrative procedure, akin to getting a license or a vaccine. The lower courts, while they were eventually overruled, showed early signs of this discomfort. They recognized that this degree of bodily intrusion demanded more than simple due process. And when the entire legal framework is engineered to create a false precedent, as evidenced by the compromised defense attorney, the court's deference to that so-called due process is rendered meaningless.
We do have to look at the persistence of the decision, though. Even acknowledging the compromised facts, the legal precedent established in Buck v. Bell survived as the law of the land for decades. It guided policy across the country and led to the sterilization of over 60,000 Americans. The core legal principle that the state could assert police power over procreation under specific administrative conditions was, well, terrifyingly effective.
But the effectiveness of a statute in enabling abuse is hardly a confirmation of its constitutional strength. In fact, the inherent legal weakness of Buck v. Bell was starkly revealed only 15 years later, when the Supreme Court addressed a similar matter in Skinner versus Oklahoma in 1942. In Skinner, the court reviewed a law that allowed for the sterilization of habitual criminals. The court struck that law down. They found it violated the Equal Protection Clause because it arbitrarily targeted criminals convicted of certain property crimes, while exempting those convicted of white-collar crimes. It was effectively sterilizing people based on their social status and the type of crime, not on any biological fact. Legal scholars have long argued that Skinner effectively distinguished Buck v. Bell out of existence by introducing this high standard of equal protection in the context of sterilization. The Skinner court essentially repudiated the underlying logic that the state could use surgery for simple social engineering. It showed the court recognized sterilization was not just a public health mandate like vaccination, but an issue that required heightened constitutional scrutiny.
I see why you emphasize Skinner as a counterpoint, and it is undeniable that Skinner introduced a crucial equal protection standard that significantly limited the application of Buck v. Bell. However, and this is vital, it's vital to note that Skinner deliberately did not overturn Buck v. Bell. The court found a way around the precedent without eliminating the precedent itself. And this non-explicit reversal is precisely why the specter of Buck v. Bell has lingered for so long. Furthermore, its influence extended far beyond American borders, tragically inspiring policies like Nazi Germany's 1933 Law for Protection Against Genetically Defective Offspring. It shows the devastating global impact of the judicial affirmation of state eugenics. And we also see its complex, dark persistence in our own jurisprudence. Justice Blackmun, writing in Roe v. Wade, actually cited Buck v. Bell to illustrate that even fundamental constitutional rights like the right to procreative autonomy are not unlimited when balanced against compelling state interests. That citation confirms that the principle, the state's potential override of procreative liberty, held a lingering, albeit dark, legal authority for decades.
But that residual authority is what allowed the tragedy to continue. Virginia, for instance, continued its sterilization program for decades after that. It only repealed the law in 1974. The court's failure to definitively overturn Buck allowed systematic abuse, often targeting marginalized populations. Poor women, Latinas, Native American women, and African Americans who were coerced into procedures, sometimes without their full knowledge or as a condition for receiving federal benefits. The victories that followed, the legal challenges like the Madrigal v. Quilligan case in California, which addressed the forced sterilization of Latina women in public hospitals, and the enactment of strict federal regulations in 1978 requiring truly informed consent, waiting periods. All of these things demonstrate the long, necessary journey of the legal system to repudiate the state as a genetic custodian. These actions, both judicial and legislative, confirm that the original rationale in Buck v. Bell was not just ethically wrong, but fundamentally unstable and constitutionally unsound. The pendulum of law eventually swung against Holmes' sweeping claim.
The journey toward that protective legislation certainly illuminates the legal failures enabled by Buck. Yet to understand the 1927 court, we have to recognize the environment of judicial deference. Holmes and the majority were convinced that by ensuring administrative due process, the hearings, the ability to appeal, they had satisfied the constitutional requirement, even for such a profound intervention. They missed the forest for the trees, focusing so narrowly on the procedure rather than the fundamental nature of the right being extinguished.
And that narrow focus is the central flaw. The lower court skepticism, which existed even before 1927, was based on a healthier skepticism toward legislative overreach. It recognized that procreative liberty deserves protection far exceeding that afforded to, say, property rights or minor health mandates. The argument that eventually won the day, whether through equal protection in Skinner or through the later regulations, was that the state must have an unquestionably compelling interest, grounded in sound evidence, to permanently alter a person's body. The evidence in Buck was neither sound nor compelling. It was engineered bias.
I acknowledge the corruption of the evidence and the ethical horror that followed. Holmes's opinion, however, stands as a powerful, if terrifying, example of judicial deference to perceived state necessity under the scientific and social doctrines of the progressive era. It permanently defines the high watermark where the judiciary affirmed police power over the most fundamental individual procreative rights, setting a dark and dangerous legal standard.
And the subsequent legal history confirms that the principles articulated by Holmes were built on quicksand. The legal and legislative corrections, from the overturning of the Indiana law to the creation of the equal protection standard in Skinner to the rigorous federal regulations protecting against forced procedures, they all demonstrate that the consensus eventually swung definitively against the notion that the state holds a constitutional right to dictate who reproduces. The true constitutional story of Buck v. Bell is not its ruling, but the decades-long legal movement required to clean up its devastation, confirming the sanctity of individual autonomy.
While the legal consensus has shifted dramatically away from the principles articulated in Buck v. Bell, its non-explicit reversal leaves us with a chilling reminder. A reminder of the complexity of balancing sweeping state interest claims against fundamental personal liberty, a debate whose shadows still illuminate issues in reproductive rights and bodily autonomy today.